Welcome back. In this episode, number 6, I will continue our conversation about exposures and risks, this time more up close and personal to the extent that they involve potential personal liability of C-suite executives and board members. We'll discuss 3 elements or sub-concepts, if you will. Number 1, the idea of fiduciary responsibility. Number 2, duty of care. And number 3, the idea of a derivative lawsuit. I'm not an attorney. I'm not practicing law. I am not providing legal advice. I encourage you to consult with inside and outside competent counsel as it relates to any matters involving privacy, security, compliance, and risk management. At the onset of this series, I set as a goal the idea of assisting you to become engaged in higher quality conversations with the C-suite and board. This is one of those areas where I believe good education on your part, helping to raise awareness in your organization, can go a long way. As a quick reminder of where we are in our journey, please have a look at this slide. It represents our overall roadmap. I expect I will record a total of 30 episodes. We're currently in episode number 6. I may decide to delete, add, change as we go along based on feedback and based on additional ideas that may come forth. All the episodes are posted on this YouTube channel. I would encourage you to subscribe if you've not already done so. Please feel free to provide feedback at any time. And last but not least, if you believe you have friends or colleagues that may benefit from this content, please share the YouTube channel link with them. Let's have a look at some very important definitions. I've included a link to dictionary.com in the references and resources section of this particular slide. First of all, a fiduciary is a person or a business with the, quote, the power and obligation to act for another, often called the beneficiary, under circumstances which require total trust, good faith, and honesty. As a result of that, you should think about healthcare organization board members and C-suite executives having to act as fiduciaries for the people their organizations serve, that is, the patients. Fiduciaries, by definition, have legal responsibilities and obligations, one of which is to execute duty of care. Duty of care is a requirement that a person, and I quote, act towards others and the public with the watchfulness, attention, caution, and prudence that a reasonable person in the similar circumstance would use. If a person's actions do not meet this standard of care, there's that phrase again, then the acts are considered negligent, and any damages resulting may be claimed in a lawsuit for negligence. In plain English, what this means is that when engaging in hospital business, trustees and C-suite executives must use the same level of judgment they would use in their own personal business activities. Finally, the idea of a derivative action as compared to a direct action. A derivative action is a lawsuit brought by a corporation's shareholder against the directors, management, and or other shareholders of the corporation for the failure of management. So, a derivative versus a direct lawsuit requires the organization to have shareholders. As a result, a derivative lawsuit may not apply in the circumstance of a not-for-profit large health system or integrated delivery network. In effect, when a derivative action is brought, the suing shareholder claims the directors and management are failing to execute their authority for the benefit of the company and all of its shareholders. This type of suit often arises when there is fraud, mismanagement, self-dealing, or dishonesty, which are being ignored by officers and board of directors of an entity. Before we look at some cases, let's tie this back to our episode number 3 on HIPAA, and specifically the ideas of reasonable diligence, reasonable cause, or willful neglect, and tie it back to our episode number 4 on medical or hospital malpractice. There's a connection. The key point is this: whether you consider the legal definitions or standards related to a fiduciary, the idea of duty of care, negligence, or malpractice, or the regulations related to privacy, security, and risk management, they both boil down to the same question. In the event of a cybersecurity incident or a data breach, both the courts and the regulators want to know the same thing. Did your organization do everything within reason that a prudent person would do, that it could do to prevent the incident from happening? Or, on the other hand, did your organization demonstrate negligence or willful neglect with respect to its enterprise cyber risk management responsibilities? There's been some recent data breach litigation that shows how corporate executives and board members can be at risk of personal liability when a cybersecurity incident occurs. In the case of Yahoo, between 2014 and 2016, there were a number of high-profile data breaches. In 2016, Verizon announced plans to acquire the core of Yahoo's internet business. The transaction was valued at $4.8 billion. Verizon ended up negotiating a $350 million reduction in Yahoo's sales price. Think about that from the point of view of shaving off shareholder value. There was a consolidated derivative complaint that was filed, contains allegations that Yahoo officials breached their fiduciary duties by, number one, failing to protect Yahoo's data, number two, failing to investigate and remediate the breaches after they occurred, and number three, failing to put proper safety mechanisms in place to prevent such attacks. In 2019, a federal district court in California approved a $29 million settlement against former Yahoo directors and officers. Now, this is, and was at the time, a very noteworthy departure from other breach-related derivative lawsuits, which had been largely unsuccessful. This one ended in a settlement. In the second case, Equifax, in 2017, there was a data breach which impacted 147 million consumers. That was followed in 2019 by a derivative lawsuit settled at a cost still quite unknown, somewhere between $575 million and potentially up to $700 million. The litigation named certain officers and directors of the organization. There was a motion to dismiss. And in fact, in the case of officers and directors, it was largely accepted. In the case of Equifax's former CEO, no. The case went on. It was the first major data breach related claim against a corporate officer which survived a motion to dismiss. And finally, in the last case, Target. In 2013, cyber attackers hit this large retailer. They gained access to the company's computer network by way of a third-party vendor, happened to have been an HVAC vendor. And they ended up accessing 41 million customer payment card accounts. Target's directors and officers were caught in the crossfire. In a series of derivative lawsuits, shareholders claimed that the retailer's board and C-suite violated their fiduciary duties. All the lawsuits were dismissed in this case. However, the CEO and the CIO were among the first to be fired as a result of the event. At the time I was writing my book, there were a number of class action lawsuits that were being filed against healthcare organizations on behalf of victims of a number of different data breaches. Among others, these suits have been filed against UCLA Health, Community Health Systems, Quest Diagnostics, Virginia Mason. It would not be surprising to see a derivative lawsuit for publicly traded companies, for example, or direct lawsuits filed against healthcare C-suite executives and board members in the future for violation of their duty of care responsibilities. In fact, a case to watch is the Spring Hill Medical Center case, which we learned about in late September of 2021, just in the case of this recording a few weeks ago. Note the comments on the left-hand side about cybersecurity standard of care. Remember that phrase, standard of care. And then look to the second bolded area. Allegations assert a bad faith failure by the directors to adequately monitor the corporation's cybersecurity system. Note on the right-hand side, comments about the Spring Hill case. In fact, there's a discussion about departures from the standard of care across a wide variety of items within Spring Hill Medical, but additionally, notice the focus on lack of appropriate assessment and risk analysis, and the phrase, patients who are at risk when hospital electronic systems are not operational. This particular paragraph that's cited there appeared at least 4 times in the lawsuit and the complaint. So if you think we're still dealing with an IT problem here, we're not. I've never thought so, and I think we're at the point where we're starting to get the attention of the C-suite and the board. So what we covered in this episode was the concept of how C-suite executives and board members have personal liability exposures. So the question I would pose internally would be, are your C-suite executives and board members executing their fiduciary responsibilities, including their specific duty of care, duty to monitor? As always, I'm ending the session with suggested actions and references and resources. I would encourage you, while the material is still fresh in your mind, to have a look at and consider some of the actions and consult with some of the resources that are provided. In the next episode, we're going to pivot a little bit and get back to some of what I call basic healthcare imperatives, including these 3 elements. I'll talk about quality and safe care, I'll talk about access to care, and I'll talk about timely care. Until then, subscribe, be well, be secure, and I'll see you in the next episode. Thank you.